right, hey everyone, it's Rudy. It's March the 20th, the year 2017. Last night I was looking for Schuyler Barbeau's letter called Does the Second Amendment Still Exist from Prison? Gary Hunt sent it to me this morning, and he's now got it up on his website. So really worked out well that Schuyler called last night, and we found this PDF file. My only challenge is it's 23 pages. So when you got something that it's gonna take a little bit of time, it's best to get started, and let's see what Schuyler's got to say here. All right, does the Second Amendment still exist? Page 1. An examination of the powers Congress possesses to regulate machine guns and other statutorily defined firearms under the National Firearms Act, Title 26 U.S.C. Section 5801 et SEQ, and the Gun Control Act, Title 18 U.S.C. Section 921 et SEQ. Schuyler Barbeau, December 9, 2016, FDC, Federal Detention Center. In this article, I am going to break down the law for you so that you may be able to understand the law as I do. I am going to prove to you that the Second Amendment right to keep and bear arms does still exist. And law I really complicated and boring. Law is really complicated and boring to try to read and understand, so I'm going to keep things as clear and simple for the layman and the common folk. I will quote from the U.S. Supreme Court cases, United States Code USC, United States Code of Federal Regulations, the United States Constitution, Bill of Rights, and maybe some other sources. Everything I quote can be looked up and verified yourself, and I encourage you to do so, that you may further educate yourself. Knowledge is power, especially when you wind up facing federal charges for exercising your Second Amendment rights. None of what I write can be guaranteed as legal advice. However, at the time of this writing, this is my nearly entire legal argument that I will be presenting to the courts for the charges I am currently facing in the federal system. I am staking my freedom on this legal theory, if you want to call it that. I have spent the last year in federal detention doing hard study into this, so there is no yanking anyone's chain here. Nobody believes that you can legally have a machine gun today without having some license or possessing one of those grandfathered ones made prior to year 1986. Well, I'm here to tell you otherwise. The government, courts, ATF, prosecutors, attorneys, organizations, and others have all worked hard to keep people in the dark about the constitutional limitations on the federal government regarding firearms. I shall shine a light on this darkness to reveal a little something called liberty. I began studying the Constitution and Bill of Rights back in 2013. I remember many people telling me how we have no Second Amendment rights anymore. In the summer, I decided I wanted a gun. I settled on an AR-15 type rifle. I did all kinds of research about everything AR-15. I spent about 5 months looking at every manufacturer for every part of the rifle. I decided that I was going to build my own. I've always liked custom anything, and I've had seen many custom builds on the internet, and that's what I wanted. I'd spend weeks looking at barrels, weeks looking at compensators, weeks on triggers, and so forth. I mainly shopped on RainierArms.com and Brownells.com, and some parts were ordered off the manufacturer's website. I studied the ballistics for 5.56223, theory of operation for the AR-15 material, silence, and the technology behind all the parts because I was essentially designing my perfect dream rifle, cost aside. The receiver set was my hardest choice because there's so many to choose from, and I wanted something unique aesthetically and high performance. I also learned about what's called an 80% lower receiver, which became critical in my build plan. I lost my place. Hold on. Oh yeah, a firearm. Hold on. A firearm is a tool for the job, so I was very particular in my selections. I wanted a highest performing select fire, short barreled, fully ambidextrous, extremely smooth operating rifle. Now, during the months of all my research, I saw in various internet forums and conversations with people the mentioning of registration and tax stamps requirements for short-barreled rifles. I got to thinking, wait a minute, I thought the Second Amendment said shall not be infringed. Yet there's all these gun control laws, and many people say these laws are all unconstitutional, and others say they are. It didn't make much sense to me, so I researched more. I looked at the Constitution and at the National Firearms Act, NFA, and Gun Control Act, GCA, statutes to try to understand how Congress can enact these laws and be legitimate, constitutional. What I determined is that under the Commerce Clause, Congress can regulate firearms that are commercially produced and the licensed importers, manufacturers, and dealers of them. I figured the ATF can only require me to register a firearm that a licensed manufacturer made because it's part of commerce. I figured, well then, I'll make my own gun and the government will not have any jurisdiction over it or me to require registration and taxes. I saw in the definition for the word firearm that a frame or receiver is considered a firearm too. This is when the significance of the 80% lower comes into play. The ATF said on their website, at least when I last read it, that an 80% lower receiver is not considered a firearm because of the state of being 80% complete in its machining. The site said because of that, because it requires advanced machining skills to complete the manufacturing process, and as long as you complete it yourself for your own personal use and remains in your possession, there are no regulations. I read that and told myself that means I can build my rifle however I want, and so I did. I ordered a really nice belay receiver set with 80% match lower and drill jigs and matching bits, and went to a relative's to use his milling machine to finish the lower. At first I only had bought and installed a full auto fire control group, trigger, and safety selector. Later on I got an M16 style bolt carrier and then made a drop-in auto sear. Dias. The sear was an experiment to see if plastic would hold up to full auto fire. I carved the Dias out of a block of what I believe to be a block of nylon plastic. I looked at a picture off the internet and eyeballed it to get it into fit and function right. It worked, but not good because I didn't make it into any specification. It was just a test to see if plastic would hold up because I had a 3D printer files for the Dias and would later try to print some out. I bought a 10.5-inch barrel for main use and an 18-inch barrel that I installed in a second upper receiver with a scope and a bipod for long-range target engagements. Because the 80% lower isn't a firearm yet, the company that manufactured it is not required to serialize it. That since there's no serial number, it can't be registered. You, as a private citizen and not a licensed manufacturer, are not required to serialize, register, and pay taxes on firearms that you make for yourself. I'll explain it further on in this article just so you know. A Dias or any other type of sear is a machine gun, as well as in statutory definitions. A licensed manufacturer is required to serialize and register them. However, an amendment to the GCA in 1986 told licensed manufacturers, importers, and dealers that they could no longer make, import, or deal machine guns unless it is on behalf of the government. But I made my own machine gun because I can, and so can you. Now I shall break down the law, the Constitution, and how and who the laws apply to. Hopefully the reader will also better understand the principle of individual freedom and liberty. The following is an excerpt, modified slightly for the purposes of this examination, from one of the legal documents I have prepared for my case. Preliminary statement. I sought to exercise my Second Amendment right to keep and bear arms, and to do this I purchased all the parts necessary to build an AR-15 rifle. I desired to exercise rights rather than privileges, rights that are constitutionally protected from infringement. Rather than privileges that can be regulated. To do this, I chose not to participate in commerce by not purchasing a rifle from a licensed firearms dealer or one that is made by a licensed manufacturer that would have traveled interstate commerce. Firearms that are produced in and that are traveling in inter or intrastate commerce are regulated, and consumers of such firearms are held to the regulations that cover them. Producing goods for and selling them to the public is a privilege that can be and is regulated by Congress and the states. Consumers participate in this commerce when purchasing goods, and in some cases are required to register and pay taxes on the transfer of possession of these goods, all of which is a privilege and is reached by Congress authority, unless explicitly expressed by the supreme law. Anything outside of this falls outside of privilege and is a right, and in some cases is explicitly protected by the Constitution and its amendments, like the Second Amendment. By machining and building my own rifle, I exercise my rights instead of privileges because Congress lacks authority to regulate or prohibit what I do privately, and my personal rights. There is no jurisdiction to charge, prosecute, and imprison me for doing nothing. I am charged for a victimless crime by laws and regulations that only apply to commerce and businesses. My detention is unlawful, and prosecution is a gross violation of my Fifth Amendment due process rights. The following explanation will show how Congress is without jurisdiction to require me or you, reader, a private citizen, to register my private property, and is without power to prohibit me or you from making, processing arms that I make myself for personal use as opposed to commercial sale and use, since due process has never taken place to deprive me of my rights. The government cannot interfere with my exercising of Second Amendment rights. Congressional power to regulate. Congressional power to regulate firearms starts with and is limited by Article 1, Section 8, Clause 3 of the U.S. Constitution, the Commerce Clause. Congress has the power to lay and collect taxes to regulate commerce between the states. Commerce is commercial activities, people in business producing goods and providing services on a large scale to the consumer public. The purpose of the Commerce Clause was to create an area of free trade among the states and foreign states, fair and equal, free from interference. See Westinghouse Electric Group versus Tully, 466 U.S. 388. A bunch of numbers, bunch of numbers, bunch of numbers, and a bunch more numbers. Congress is without power to regulate or prohibit private activities. The Gun Control Act, GCA, and National Firearms Act, and NFA, were enacted under Commerce Clause authority, and the Supreme Court has ruled them unconstitutional under the same. It is well established and understood that Congress has no general police powers. Congress does not have police power to tell me or you I can't make, keep, or possess, and if I wanted to, sell a firearm I would make for myself. If a constitution, is it constitutional to enforce an excise tax on the doing of business when you as a private citizen are not engaged in business? Is it constitutional to enforce laws regulating licensed business engaged in commercial activities on a private citizen who is not engaged in commercial activities? Is it constitutional to subject a private citizen exercising his protected and unalienable rights to laws regulating the privilege or participating in interstate commerce when he is not engaging in or conducting any such activities? I think not. At the most, only states have police power to tell their citizens they can't make something. But when it comes to arms, not even the states can interfere. Article 6, Clause 2, this Constitution shall be supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutions or laws of any state to the contrary notwithstanding. Article 5 says the amendment shall be valid to all intents and purposes as part of this Constitution. State cannot interfere with personal rights but can regulate privileges like the business and commerce. If the acts reach private activities and private property, then they are unconstitutional because the power for federal government does not exist. If the NFA is not an excise tax on doing of business, as was ruled by the Supreme Court in Sonzinski, filed 722-300 U.S. 506, then it is unconstitutional to enforce law on private citizens not engaging in business. The executive branch is enforcing tax laws contrary to the intent of the law and of Congress. As will be explained more later, Congress has a boundary that its reach can't cross, and it lies between commercial activities that do substantially affect interstate commerce and activities that don't. My activities were not even commercial and were purely interstate. In Mugler versus Kansas, bunch of numbers, quoting Justice McLean from the license cases, 46 U.S. 5 How, bunch of numbers. Supreme Court, a state regulates its domestic commerce, contracts, transmission of estates, real and personal, and acts upon internal matters which relate to its moral and political welfare. Over these subjects, the federal government has no power. Mr. Justice Woodbury observed, how can they, the states, be sovereign within their respective spheres, without power to regulate all their internal commerce, as well as police and direct how, when, and where it will be conducted in articles intimately connected either with public morals or public safety or public prosperity? Mr. Justice Greer, in still more emphatic language, said that the true question presented by these cases, and one which I am not disposed to evade, is whether the state have a right to prohibit the sale and consumption of an article of commerce which they believe to be pernicious in its effects, and the cause of disease, pauperism, and crime. Without attempting to define what are the peculiar subjects of this power, it may safely be affirmed that every law for the restraint or punishment of crime, for the preservation of the public peace, health, and morals, must come within this category. The police power, which it is exclusively in the states, is alone competent to correction of these evils, emphasis added. So far in this case, we see that the Supreme Court talking about the states needing police power to deal with the making of alcohol for commercial sale to try reducing the evil effects of alcohol on society. The case deals with the state of Kansas putting a prohibition on the commercial making and sale of alcohol. The Supreme Court continued in this case. These cases rest upon the acknowledged right of the states of the Union to control purely internal affairs, and in doing so, to protect the health, morals, and safety of their people by regulations that do not interfere with the execution of the powers of the general government or violate rights secured by the Constitution of the United States. The power to establish such regulations, as said in Gibbons versus Ogden, reaches everything within the territory of a state not surrendered to the national government. The GCA and NFA specifically tax and regulate people who specifically and intentionally engage in interstate commerce outside of people who want to manufacture and sell firearms to customers outside of the state of origin. Congress has no power because it's a purely internal affair, and even the states have to be wary of interfering with its citizens' personal rights. The federal government has no power over our private activities, and even in our activities where we're commercial in nature, and they take place only within your state's boundaries, they can't substantially affect interstate commerce, and Congress can't interfere. The Supreme Court continued. It is, however, contended that although the state may prohibit the manufacture of intoxicating liquors for sale or barter within her limits for general use as a beverage, no convention or legislature has the right under our form of government to prohibit any citizen from manufacturing for his own use, or for export or storage any article or food or drink not endangering or affecting the rights of others. The argument made in support of the first branch of this proposition, briefly stated, that in the implied compact between the state and citizen, certain rights are reserved by the latter, which are guaranteed by the constitutional provision protecting persons against being deprived of life, liberty, or property without due process of law, and with which the state cannot interfere. That among those rights is that of manufacturers for one's use of food or drink. Our system of government, based upon the individuality and intelligence of the citizen, does not claim to control him, except as to conduct to others, leaving him the sole judge as to all that only affects himself. Although this case is about alcohol, we can substitute arms, and the concept remains the same. I made my rifle for my own use, and this making and possession did not endangering or affect the rights of others. My right to make, keep, and bear arms are rights reserved by me and you. I have never yielded those rights to any government. Our rights are not granted to us by any federal or state constitutions. Our rights do not exist as a creature of any statute. Our rights are natural, personal, and unalienable. No government can interfere. If the Supreme Court says a man has a right to manufacture alcohol for his own use, and not even a state with its police powers can interfere, and with no amendment protecting that right, then certainly with the Second Amendment existing, no state or federal governments can interfere with our making, keeping, bearing, or even occasionally selling arms. The Supreme Court continued, the right to manufacture drink for one's personal use is subject to the condition that such manufacture does not endanger or affect the rights of others. If such manufacture does prejudicially affect the right and interstates of the community, it follows from the very premises stated that society has the power to protect itself by legislation against the injurious consequences of that business, as said in Munn v. Illinois 94 U.S. 124-2483. While power does not exist with the whole people to control rights that are purely and exclusively private, government may require each citizen to conduct himself and so use his property as not unnecessarily to injure another. When I made my machine gun, I exercised my purely and exclusively private rights and did so with no intention to harm any other citizen. In fact, from the day I built the rifle until the day I was arrested, over a year and a half, no one was ever injured or had their personal rights infringed upon. In fact, one of the reasons I built the rifle with the capabilities mine has was to protect and defend any and all citizens of America and their rights, freedom, and liberty, not to endanger or unnecessarily injure another. I was always careful not to infringe upon or harm others. The Supreme Court further said in Mugler, it does not follow that every statute enacted ostensibly for the promotion of these ends is to be accepted as a legitimate exertion of the police powers of the state. There are of necessity limits beyond which legislation cannot rightfully go, while every possible presumption is to be indulged in favor of the validity of a statute. Sinking Fund Cases 99 U.S.C. 718-25-501. The courts must obey the Constitution rather than the law-making department of government, and must, upon their own responsibility, determine whether in any particular case these limits have been passed. To what purpose? It was said in Marbury versus Madison, 5 U.S. 1 Cranch, 137, 167, 2, 6070. Are powers limited, and to what purpose is that limitation committing to in writing? If these limits may at any time be passed by those intended to be restrained, the distinction between a government with limited and unlimited powers is abolished. If those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation, the courts are not bound by mere forms, nor are they to be misled by mere pretenses. They are at liberty, indeed, are under solemn duty, to look at the substance of things, whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If therefore a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to adjudge and thereby give effect to the Constitution. Emphasis added to all quotations from Mugler. My case is in any particular case, and the court should look at the substance of things. The right to keep and bear arms, even a machine gun, is secured by the fundamental law, and the court should so adjudge and give effect to the Constitution and our mind liberty. It's not up to the courts, even the U.S. Supreme Court, to decide which arms we citizens can and cannot have. The matter was decided by the framers of the Constitution and the Bill of Rights, and they said to the federal and state governments, the right of the people to keep and bear arms shall not be infringed. Arms is any weapon. On top of that, there is no delegated authority to the judicial branch to interpret the supreme law and tell us we only have the right to keep certain firearms, and that the Second Amendment only protects firearms that the court says it protects. The courts and some members of the public would contend that, well, the First Amendment is not absolute because some speech is harmful, like libel, slander, defamation of character. I agree on that point. However, unlike some speech actually producing an injured party/victim, how does me keeping a machine gun produce an injured party? How have I inflicted harm on someone? And what delegated power does any branch of the federal government have to ignore Second Amendment's instruction? The purpose of the federal government was to manage the several states' governments. The job of the state government is to manage their citizens. That is why we have the 10th Amendment and why only the states have police powers. To understand this better, you have to understand history. The colonists used to ask, who are they, British Parliament, 3,000 miles away to tell us how to live our lives? Who are they, 3,000 miles away to think they know best how to manage us? The Founding Fathers designed the new central government with the past issues in mind, giving specific powers and limitations so that the citizens of the Union would not ever have to deal with such tyranny again. Apparently, that wasn't enough, though. Interstate and intrastate commerce. The Commerce Clause allows Congress to regulate firearms because there are companies who manufacture and sell firearms across the nation, creating a commerce stream in national markets, which Congress can legislate to regulate. There is no dispute of the fact, for that is precisely what Congress' intent and purpose for the Gun Control Act 18 U.S.C. 921 et seq. and the National Firearms Act 26 U.S.C. Section 5801 et seq. is to regulate commerce and crime involving commerce. It is well settled that Congress can regulate interstate activities. In Michigan versus Wisconsin, PL Company versus Calvert, bunch of numbers. The Supreme Court referenced Memphis Natural Gas Company versus Stone, bunch of numbers, saying it is now well settled that tax imposed on a local activity related to interstate commerce is valid if and only if the local activity is not such an integral part of the interstate process, the flow of commerce, that it cannot realistically be separated from it. See also United States versus Lopez, bunch of numbers. Gonzalez versus Raich, bunch of numbers. My local activity of making my own and possessing my machine gun, not even being commercial activities in nature, are not such an integral part of any flow of commerce stream. Therefore, an imposition of tax imposed by the NFA can be valid. Any United States versus Henry, bunch of numbers, and Gonzalez versus Raich arguments are reasonings for reaching my private activities are foreclosed. The analysis by the Supreme Court has extended Congress reach and the Commerce Clause to business that only operate within a single state's borders and have no outside contracts. However, only businesses and commercial activities may be reached. The Supreme Court in Raich and said Congress may regulate 1. the channels of interstate commerce, 2. the instrumentalities of interstate commerce, and persons or things in interstate commerce. And 3, activities that substantially affect the interstate commerce. All 3 of these things are aspects of a business or commercial enterprise. The court in Lopez, referencing Raich, said Congress, under the federal Constitution's Commerce Clause, Article 1, Section 8, Clause 3, may regulate 3 broad areas of activities: the use of the channels of interstate commerce; 2, the protection of the instrumentalities of interstate commerce or persons or things in interstate commerce, even though the threat may come from interstate activities; and 3, the activities that substantially affect interstate commerce. Where economic activity substantially affects interstate commerce, congressional legislation regulating that activity will be sustained. Emphasis added, all of which I had no part in. No channels were used, no persons or things of firearm traveled in interstate commerce, no instrumentalities were utilized, no threats were made to those things, and I was not engaged in any economic activity. So how could Congress possibly have jurisdiction over my private making and possession of my firearm for personal use, and under what delegated power? The Supreme Court said they would not pile inference upon inference in a manner that would be bid fair to convert congressional authority upon the Commerce Clause to a general police power of the sort retained by the states. Further, the Supreme Court said in Lopez, but even the modern era precedents which have expanded congressional power under the Commerce Clause confirm that this power is subject to outer limits. In Jones versus Laughlin Steel, the court warned that the scope of the interstate commerce power must be considered in light of our dual system of government and may not be extended so as to embrace effects upon the interstate commerce so indirect and remote that to embrace them in view of our complex society would effectually obliterate the distinction between what is nationally, what is local, and created a complete centralized government. Bunch of numbers. Congress may regulate interstate activity that has a substantial effect on interstate commerce. Wickard, super bunch of numbers. Congress may regulate activity that exerts a substantial effect on interstate commerce. Emphasis added. The judicially enforced outer limits mentioned above are established in between intrastate commerce activities that do not substantially affect interstate commerce and interstate commerce activities that do not substantially affect interstate commerce. The Supreme Court said activities that are beyond the reach of Congress under the commerce power are those which are completely within a particular state, which do not affect other states, and with which it is not necessarily to interfere for the purpose of executing some of the general powers of the government. Katzenbach versus McCulling, bunch of numbers. Congress power ends at a substantial effects on commerce, and the activity has to be commercial. Then beyond that horizon are activities that have nothing to do with commerce, that are personal and private. If the Supreme Court says they will not pile up inferences to gain cause to extend the reach of Congress, then neither should the lower courts or the government. The Supreme Court has ruled that the Second Amendment does not make the right to keep and bear any arms absolute, and I only agree that in certain cases government can regulate firearms and people's rights, like firearms that are commercially made, people licensed and engaged in business, people convicted of violent crimes, mentally ill, and minors. But the federal government still does not have police powers to deprive rights by acts of Congress. I agree that the Constitution permits some regulation of firearms, but only when they are traveling in interstate commerce and businesses that manufacture, import, and deal with them, because any further regulation or prohibitive scheme would extend the reach of jurisdiction across the boundary into the shall not be infringed territory of the Second Amendment, while possibly simultaneously violating the 10th Amendment. Congress does not have general police power delegated to it, only power to regulate commercial activity. My activities were non-economic, non-commercial, and private, 2 steps beyond the boundary and over the horizon. That same goes for anyone else who makes their own machine gun or any other type of firearm. So under what power does Congress have to tell me I cannot make my own machine gun? Under what power does Congress have to tell me that I must register my private property and pay taxes on those non-commercial activities? Under what power can the executive branch enforce law on citizens for their private activities when the law is meant for businesses? Is this not tyranny? If we do not avail ourselves to the law, how can we be bound to it? Merriam-Webster's Dictionary of Law 2014 defines infringe as to encroach upon in a way that violates law or the rights of another. Encroach is defined as to enter gradually or stealthily upon another's property or rights. Congress might be abusing its Commerce Clause power to sidestep and go around the Second Amendment's instruction that rights secured are not to be infringed or encroached upon. Utilizing the Commerce power to regulate firearms and then apply Section 922O as police power or the executive, it's enforcing it as if it were a police power, is entering gradually or stealthily, and constitutes a usurpation of power. Right now, the government wishes to prosecute me and under acts intending to tax and regulate businesses and commerce, and are treating their provisions as police powers, which only the states have. The purpose of the Gun Control Act, 18 U.S.C. Section 921 et seq. Congress made a declaration in Section 101 of the Gun Control Act of 1968, Public Law 90 through 618, which provides, the Congress hereby declares that the purpose of this title is to provide support to the federal, state, and local law enforcement officials in their fight against crime and violence, and it is not the purpose of this title to place any undue, unnecessary federal restrictions or burdens on law-abiding citizens with respect to the acquisition, possession, or use of firearms appropriate to the purpose of hunting, trap shooting, target shooting, personal protection, or any other lawful activity, and that this title is not intended to discourage or eliminate the private ownership or use of firearms by law-abiding citizens for lawful purposes, or provide for the imposition by federal regulations or any procedures or requirements other than those reasonably necessary to implement and effectuate the provisions of this title. So there you have it. Congress said the act does not eliminate the private ownership of firearms, and I privately made, owned, and used my machine gun for lawful purposes. Yet the government is trying to tell us that Section 9220 eliminated the private possession of machine guns made after 1986, even though Congress said otherwise. Did Congress eliminate private ownership with Section 9220, or did they only tell licensed manufacturers, dealers, and importers that they could no longer manufacture, import, and deal machine guns unless on behalf of the government? I made a declaration to the court explaining my lawful intentions for making and using my rifle, which are in keeping with exactly what Congress declared the Gun Control Act was not intended to interfere with. I am a law-abiding citizen, having never been convicted of any crime, and was using my firearm for lawful purposes, mainly for target shooting and personal protection. My acquisition of my rifle was not through commerce, as I made it myself, and my ownership of my property was private. Section 9220, as the government is trying to apply it as a police power, eliminate my private ownership, which is exactly what Congress cannot do, and declared it was not intending to do. Statutes criminalizing the possession, transfer, and making of machine guns are merely malum prohibition laws. In contrast to rape, murder, and robbery, such gun-related activities are not inherently bad. They are only technically or artificially illegal. Courts, however, must defer to Congress when it legislates pursuant to its enumerated powers. Ardoin 19F3 emphasis added, well, courts must defer to Congress, and Congress said they are not eliminating private possessions of firearms. That includes machine guns and any other type of firearm. If the courts determine that Section 9220 is not a statute enacted and enforced under police power, then it must be a commerce power. But how can it be applied to me or anyone if we don't participate in commerce? When I say participate in commerce, just to clarify, I'm talking about buying firearms as a whole gun, as whole guns, not parts or materials, because that's what the law covers. There are many cases that also say what the purpose of the act is. Principal purpose of the Gun Control Act of 1968, 18 U.S. 921 et seq. is to curb crime by keeping firearms out of the hands of those not legally entitled to possess them because of age, criminal background, or incompetency, and to channel commerce in firearms through federally licensed importers, manufacturers, and dealers of an attempt to halt mail order and interstate traffic in firearms. Huddle versus United States, a bunch of numbers. Principal purpose of 18 U.S.C. 922 was to make it possible to keep firearms out of the hands of those not legally entitled to possess them because of age, criminal background, or incompetency. Barrett versus United States, bunch of numbers. Purpose of Congress in enacting Gun Control Act of 1968-18 is to eliminate firearms from the hands of criminals while interfering as little as possible with law-abiding citizens. United States versus Weatherford, bunch of numbers. In enacting Gun Control Act of 1968, Congress intended to regulate all businesses engaged in importing, dealing, manufacturing firearms concerning interstate as well as intrastate transactions so as to assist states effectively to regulate firearms traffic within their borders. United States versus Patriot, bunch of numbers. Emphasis that I was not a business, nor was I engaged in any commercial transactions, nor was I participating in commerce by the purchase, a transaction of a firearm from any business where it would be covered by the acts. If I am not under these laws, and neither are you if you make your own firearms like I did. Gun Control Act 18 U.S.C. Section 921 exec was intended to be broad measure to correct widespread abuses in traffic in firearms. United States versus Swinton, bunch of numbers. 922 is intended to dry up supply of crime guns completely for felon. United States versus Haddad. Purpose of Gun Control Act of 1968 is to limit possession of firearms to those persons who are responsible and law-abiding. Barker versus United States, bunch of numbers to us, to eliminate supply of firearms available to felons through interstate and foreign commerce. United States versus Rivera. Purpose of Gun Control Act of 1968 is to strengthen federal controls over interstate and foreign commerce in firearms and to assist the United States effectively regulating firearms within their borders. United States versus Busick, bunch of numbers. Federal regulation of interstate sales of firearms does not constitute unconstitutional usurpation of state power, since the transactions encompassed therein involved licensed dealers whose general involvement with interstate commerce is substantial. United States versus Crandall, bunch of numbers, subsections, bunch of numbers as amended, which criminalizes certain activities affecting commerce, are jurisdictional words of art, and subsection reaches only those firearms that travel in interstate commerce. United States versus Wallace, bunch of numbers. Upon reading the entire act, the intent of Congress, in cases involving the GCA, one can determine that it pertains to people and businesses engaged in commerce and applies only to firearms that travel in interstate foreign commerce between those licensed manufacturers and importers and the dealers of their firearms. Otherwise, Congress is without jurisdiction. Firearms in private possession are no longer products floating down the commerce stream. The government may contend, and many other people, that even making a one-time sale of a rifle, your private property, constitutes commercial activity. However, a dealer is who the law applies to and is defined in the statutes and code of federal regulations, and one time of periodical sales of private property does not make us a dealer as defined. Thus, it doesn't satisfy the elements of any crime. The term transfer in the GCA and NFA only applies to dealers, manufacturers, and importers who transfer possession of their businesses' inventories in interstate and interstate commerce and are licensed under the law to do so. Under federal law, individuals may not deal in firearms without first receiving a license. Individuals without licenses may make periodic sales of firearms from other personal collections, although they may not engage in the regular course of business of dealing firearms for a profit. When a purchaser buys a firearm from a lawfully licensed dealer, both the dealer and the buyer must record the transaction. A Bureau of Alcohol, Tobacco, and Firearms and Explosives 4473, a transaction record form that dealers are required to keep by law. Federal law, GCA and NFA, requires licensed dealers to maintain acquisition and disposition record books, which are also used to record information about transactions. United States versus Shipley, bunch of numbers. As you can read in that case, the only time the transactions have to be recorded is when someone buys a gun from a licensed dealer, and the records of such must be kept by the dealer. The law doesn't and cannot say that private citizens have to record the transfers, because Congress is without constitutional delegation of power to write such law, and only Congress writes the law. Under the law, licensed manufacturers and licensed importers are required to serialize their manufactured and imported firearms. Since I am not a licensed manufacturer or importer, I was not required by law to serialize my AR-15 when I made it. Only licensed dealers and purchasers are required to record their transactions, transfers, but I am not licensed, so I am not required to record any transactions, nor could I, since my rifle is not serialized, and because it was part of my personal collection. If I wanted to sell my rifle, it would not be transferring from a business inventory into a private collection. 18 U.S.C. bunch of numbers licensing says, upon filing of a proper application and payment of a prescribed fee, the Attorney General shall issue a qualified applicant the appropriate license, which, subject to provisions of this chapter, bunch of numbers, and other applicable provisions of the law, NFA shall entitle the licensee to transport, ship, and receive firearms and ammunition covered by such license in interstate or foreign commerce during the period stated in the license. Emphasis added. A person only becomes subject to the laws after they get the license or when engaging in business without one. Do you see how the statute says they are firearms and ammunition covered by the license? Covered firearms are those made and imported by licensed manufacturers and licensed importers, and they dealt by the licensed dealers. These covered firearms are the ones required to be serialized and registered if they are of the type defined in 26 U.S.C. 5845A. If there are covered firearms, there must be firearms not covered. Those would be the ones you make yourself. When Section 92020 is read, the context of the entire act as it should be, it tells the licensed dealers, importers, and manufacturers they cannot make, deal, and import machine guns unless it is on behalf of the government, and that they, the licensees, and all other persons cannot possess any machine gun that was made by the government after 1986, unless authorized by the law to do so. My rifle was not made by a licensed manufacturer for the government, so there is not any violation in that way. I am not a licensed manufacturer who has made a machine gun, nor for the government, which would have violated the law, because only licensed manufacturers can make machine guns for the government, not for the civilian market. 9220 tells us licensed dealers that they cannot transfer machine guns made after 1986 to civilians, only to the government. I am not a licensed dealer, so I cannot violate that law if I want to sell my private property to someone. The purpose of the National Firearms Act, 26 U.S.C. 5801 exec. In enacting the NFA, Congress sought to regulate the sale, transfer, licensed machine guns, sawed-off shotguns, sawed-off rifles, and other firearms other than the pistols and revolvers which may be concealed on the person, and silencers, HR Rep number 75-2457 at 1/1938. As I understand, the primary purpose of the bill is to stop gangsters from getting hold of machine guns. Statement of Rep. William P. Connery, Jr., 78. When Congress passed the National Firearms Act in June 1934, imposing a tax on dealers in firearms and the traffic of firearms, the purpose and intent of the Congress was without question directed at the Dillingers, mob barkers, and gangsters who were plaguing the country with crimes of violence. McBee, First National Bank of San Diego, bunch of numbers. The National Firearms Act arose from a motive to prevent racketeers, bank robbers, and desperados from obtaining sawed-off shotguns and machine guns to run wild in crime and to enable the government to trace ownership. United States versus Adams, bunch of numbers. At the time in those days, only blacksmiths and manufacturing companies were able to make guns because of the limited technology of the time and knowledge. The average citizen didn't have the means to ease to make advanced weaponry at home like we do today. When you begin reading the act at the beginning in section 5801, it says, on first engaging in business, every importer, manufacturer, and dealer in firearms shall pay a special occupational tax for each place of business. And then you move to the next section 5802, and it says, on first engaging in business, each importer, manufacturer, and dealer in firearms shall register, in which such businesses is to be carried on each location where we will conduct such businesses. When a person registers his business, he shall receive the appropriate license, which, subject to the provision of this chapter and other applicable provisions of law, shall entitle the license to manufacture, import, and deal firearms, the appropriate license being a class 1, 2, or 3 under CFR section 47932B. Then after 5802, the preceding sections are what a person engaging in a business and licensed to do must obey. This is the context that must be applied. At the time the NFA was written, there were only businesses manufacturing machine guns, and the law only addressed them, requiring serial numbers for registrations and tracing purposes, and to aid taxation of the manufacturing and dealing transactions that constitute the commercial activities that Congress has jurisdiction to tax and regulate. What people do privately and non-commercially does not give Congress Commerce Clause jurisdiction or police power jurisdiction, necessary and proper clause jurisdiction. Context. One should not read in a single subsection of a section of an act and attempt to apply it in all cases, activities, or conduct as many federal agents and the courts do in prosecuting citizens. In expounding a statute, we are not guided by a single sentence or a member of a sentence, but look to the provision of the whole law and its object and policy. Pilot, life, insurance, ditto, bunch of numbers. In concluding, we do nothing more, of course, than follow the cardinal rule that a statute is to be read as a whole. See Massachusetts versus Morash, bunch of numbers. Since meaning of a statutory language, plain or not, depend on the context. See Shell versus Iowa, Department of Revenue, bunch of numbers. Words are not pebbles in alien juxtaposition. They have only a communal existence, and not only does the meaning of each interpenetrate the other, but all the other aggregate take their purport from the setting in which they are used. NLRB versus Federish Companies, bunch of numbers. King versus St. Vincent's Hospital, bunch of numbers. Those were all Supreme Court case citations when a subsection 9220 or 5861D are read out of context. The government can and does misconstrue their application, apply police powers not delegated, and violate a citizen's Second, Fourth, and Fifth Amendment rights, as well as the state's 10th Amendment rights. Conclusion. The federal government has their hands tied when it comes to the Second Amendment and privately owned firearms. If you make your own firearm, you can make it however you want, and you do not have to register it or get the tax stamp. For a few years, I've argued with people who said I can't do what I did, and I've always said, okay, show me the law. But no one ever has in this paper. In this paper, I have shown you most of the law. There is still much more in the GCA and NFA and in the Code of Federal Regulations Parts 478 and 479 that could help explain my position. Everything I did was legal. I hide nothing, nor did I have to try to sneak around trying to buy parts. Most everything was ordered and shipped right to my apartment door, and the rest was bought over the counter at my favored local shop. No tricks, no smooth moves. I did it because I could do it. Go to a dealer and try to buy an SBR or suppressor without registration and tax stamp. You won't be able to because you can't. A dealer cannot transfer a registered firearm to you without complying with all the laws and regulations, but you could make your own at home if you got the skills and access to machining equipment, or maybe someone to help you. Don't be fooled by the ATF or any other government or law enforcement. They don't study all the law, especially the supreme law, to which they swear an oath to support and defend. They don't want everyone running around with machine guns, SBRs, and suppressors they made at home. All right, that is Schuyler Barbeau. This is his address. I believe he is an embodiment of the American liberty, spirit of liberty. And he is a patriot, American patriot, a political prisoner, and we should write to him in prison and encourage him. May God bless him, and may God lead his steps forward, and may God be with his family, Stacy Barbeau. And I pray that God brings him freedom soon. Thank you. God bless.